Okay, today we're going to do the second round of contracts. So we learned about last week how a contract is created, the formation, that there can be an oral, there can be written contracts, how long the contracts are valid for. Today we're going to talk about, so once you guys enter into a contract, if something goes wrong, and how do the courts interpret that? How do people understand what the contracts mean? And are there rules or procedures in trying to figure out what the parties meant? If you think about it, you're going to go to court. The basic is somebody doesn't deliver on a contract. You know, I enter into a contract. You're going to design me a house. I'm going to pay you $100,000. I decide not to pay you the $100,000. Seems pretty simple. I did the work for you. You owe me. Cut and dry. But what ends up happening in the law, what happens in real life, is I say I'm not going to pay you the $100,000 because I don't think you did a good enough job. Or I think you were supposed to do A, B, and C, and you only did A and B. And you might say, well, I did a good enough job, so you owe me the $100,000, and I did A, B, and C, and there becomes a disagreement as to what C might be. You read the contract as saying, I was supposed to deliver C and it was supposed to be this. I look at it as C as something different. If you think about it, while contracts are supposed to have a meeting of the minds, an agreement, like we learned last week, between the two parties, there is never going to be a perfect contract. Just like when you guys design a building, you're never going to design a perfect building. There's always going to be something, whether you want to call wrong with it or not, it's not going to be, the drawings are not going to be 100% complete. You are never going to detail every single window on a facade. You're going to detail one window, and that's going to be what they build off of that. And then the contractor comes in, and they have rows and rows of windows, and they're installed, and they're all supposed to be in accordance with the one detail. But you haven't drawn every single thing. And so maybe they get to, when the contractor gets to an area where the connections or where the window sits is a little different than the majority of it. Maybe it's on a corner. Maybe it's where there's a wall in the interior coming in. Maybe it's the structure of the building, how the brick courses come in. You might not have drawn that. So you, in creating your drawings, can't create a 100% every single thing for that building. Same thing with a contract. You are not going to put in every single rule and code and obligation into that because the contract would be massive. One of the things that's frequently put into a construction contract, whether it's the design professionals or the contractors, the construction side of it, is that the design professional is supposed to design in accordance with the codes, laws, and regulations applicable. Because if you had to actually attach and write every code, law, and regulation applicable, again, it would be volumes. So you say in general, and then you put an obligation on the architect to determine what codes, laws, and regulations apply to this project. Same type of language is going to be found in a construction contract. And then what ends up happening is as you go further down the road, maybe there's a disagreement because the contract's not complete, or not word for word complete, as to what those codes, laws, and regulations were applicable. So what you have to do then is if you have this document that has created a meeting of the minds and agreement between the parties, but is not 100% word for word down to the minutia, when there's a dispute, then you've got to go in and the courts have to figure it out. So that's what we're going to do in the interpretation of contracts. How do we interpret what's in there? How do we get the rules of the road to make sure we see what the parties agree to? And then we'll have a couple examples of breaches of contract and the types, and then from that, what are your remedies if there's a breach and you're the party that's what we call the injured party. And I'll use that term throughout the semester, injured party. It doesn't necessarily mean physical injury. It means the party who suffered a loss. And it could be a financial loss. It could be an opportunity loss. It depends on what it is. So we're going to go through that. And we'll talk about how you understand, interpret, then what happens with a breach, the types of breaches, and then ultimately the costs. So first off, for the interpretation of the contract. What's the goal? Why do we want to do this? Well, it's to effectuate the intent of the parties. When we interpret, we want to, as the courts, The trier of fact is another term that we use. They're the people that receive the facts and try to ascertain or distill what the facts are. It's different than the trier of law. The trier of law, let's say you're on a jury trial. When you are presenting evidence are the facts. The jury is the trier of fact. The jury takes all those facts in and balance and weighs and sees which facts are more important, which facts ring true or not. They bring all those facts in and interpret. That's the trier of fact. The trier of law in a jury trial is the judge. And the judge is going to say, okay, jury, you can look at these facts. The law says you must set the following rules. So in this instance, to effectuate the intent of the parties, what you're going to try to do is you're going to try to take the facts that put this document together, but you're going to start by looking at the actual bargain. You're trying to figure out what that actual bargain is between these parties. That's the trier of facts job. If you're in a jury trial, the judge is not going to determine what the contract means. The jury will, because they are looking at the facts. The judge is going to tell the jury what rules. If you're in a trial, and a lot of trials, just so you know, many trials in our system on the civil side are not jury trials. So jury trials are always going to be in criminal. You're entitled to a jury of your peers. We talked a little bit about that in the first lecture. On the commercial side, the civil side, you get to pick and choose. The plaintiff, the injured party, whether it's going to be someone that's physically injured or a loss they suffered for some type of breach or otherwise, is often allowed to choose whether they want to have a jury or not. I will say in most instances in construction cases, you do not want a jury trial. And there's one very basic reason for it. You guys do drawings all the time, and you can imagine. How many people here have worked for an architectural firm? Anybody here? Okay, so a little more than half you guys. When you get down to construction documents, there are hundreds and hundreds of documents. And then from there, those go to the contractors, and they have their subcontractors create shop drawings. And then there's RFIs, and there's requests for information on RFI, and there's all these documents that are in a case, in a project. Thousands and thousands and thousands of pages of documents. If you wanted to try that in front of a jury, about 3 days in, they'd all be glassed over. They'd be like, which document was what? They would lose their minds. And when you're in a jury trial, you need, because they're not used to the situation, as the lawyer, you want to present all the evidence and all the facts, because in pieces for them to try to understand. Normally, you want to do that in front of a judge only. The judge is used to assimilating documents. They're used to the process and procedure. So I would say, by and large, the majority of construction cases are going to be judge only, not judge and jury, but occasionally you want to go jury. In that situation, when it's a judge, the judge is both the trier of fact and law. They will wear both hats. But ultimately, the goal in interpreting contracts is to determine what the actual bargain is. Okay? That's the first thing we want to do. Second, the court or the arbitrator, or in this case, the jury, if it's going to be a trier of fact as a jury, they will not rewrite the contract. They are not allowed. So this is a rule. If the contract says X, and somebody gets on the stands and says, no, but I thought it meant Y, the trier of fact must look to the language of the contract first, because that was what the deal is that everybody signed. They are not allowed to basically go outside of what they call the four corners of the contract. If it's clear and unambiguous and it's written in the contract, the court, the arbiter, or the jury cannot rewrite that language. So clear and unambiguous. Okay? And then the next thing, so that's one thing as far as another goal and intent. Third is, what was the agreement? And did the parties perform as promised? What was the agreement between? Again, they're trying to figure it out. And did they both perform? So that's when the trier of fact has to look to the actions of the party. Then they take the words in that contract, or if it's an oral agreement, the language that was exchanged between the two, and they say, did they perform in accordance with those written rules? That's the goal, to get the intent of the parties. So, let's see about these guys. See if they performed as they should have.
It is done. It's a signed document. canceled on. This year, I'm really going to take that football. Peculiar thing about this document, it was never notarized.
Okay, so this might have been a little better slide for last week, but so the agreement between the parties there was that Lucy was not going to pull the football away. Now, she did end up pulling the football away because, as she says here, she tries to use it as an escape clause, that the contract was never notarized. It was signed, it was a signed document. So we know what the agreement between the parties are. So the trier of fact here would go in and they couldn't change the words, they would look to the agreement. So let me ask you a question. Do you think, anybody have an answer? Do you think Lucy's excuse that the document was not notarized, how many people think that that is a legitimate answer, a good excuse here? Anybody? Okay. And somebody tell me why they think that that's not valid. Anybody have an idea? Why just because it's not notarized, why that's not valid? Anybody have an idea? Okay, let me explain. So we talked about last week, and I said this might have been a little bit better for last week, but I thought I didn't have time to throw it in, but I wanted to bring it back here in looking at the intent. The most important thing is here is the promise that's made. If we remember last week, there can be an oral contract and there can be written contract. So if you have an oral contract, you're never going to have a signature. So you don't need to have a signed document to actually have a promise. In fact, if Lucy had just, like she always does, promised she wouldn't pull the football away, every single time she did, she would have breached the contract. And that Charlie Brown has an expectation that she is going to deliver on that promise. So the certain part of this here is that now she gives him, and that you could actually say, one could go so far in this example here, is to say that by giving the written contract to Charlie Brown, because he's gotten wise to her ways, he knows she's going to pull it if she makes the oral promise and is going to breach that. She's given him a written document, yet she always has the intent to pull it away. One could argue that she's actually defrauded Charlie Brown here. In fact, there could be an argument we'll get a little later on as far as damages, that Charlie Brown, in addition to his potential injury damage, there's a personal injury he suffered, if he had any monetary damages, he could actually go after her for fraud. Because she always intended to pull it away and was going to use the excuse of it not being notarized. Now, a contract need not be notarized, just so you guys know. Notary is used often, though, because it can be used to say someone has sworn or averred to it, because they're actually swearing under penalties of perjury and other fines. So, you don't need to have a written contract for this type of transaction. You don't need to have, even if it's written contract, if it's signed, it need not be notarized. So in both instances, Lucy has gone beyond her promise, has breached her promise, and I would argue in this case, potentially defrauded Charlie Brown. So, all right, let's move on. Okay. When we want to determine what the contract means, then that was really basic between Charlie Brown and Lucy. We just know that she says, I promise to leave the football there if you run and kick it. But in other instances, something that's a little more deeper. There's a lot more things in the document or the contract, the agreement between the parties, other than I'll hold the football so you can kick it. So how do you do that? How do the courts and ultimately the trier of fact go through it? What are the rules? Well, the first analysis is to take a look, like I said earlier, on the objective language of the contract. Objective, not subjective. So objective means you have to actually look at the clear and unambiguous language, and it is always enforced as written. If it says, I will not pull the football, there is no interpretation that can be made of that. There is no, but it's not a notarized contract, so it's not clear and unambiguous. In fact, the signature and the notary for that is irrelevant. What's relevant is that the agreement is, I promise to hold the football for you when you go to kick it. It is clear and unambiguous, and it is always enforced as written. That's one of the first rules. And so when you are in court, when you are presenting your case, if there's a construction case that's gone wrong, a project's gone wrong, or an owner or an architect, and it says to you, it says between us, you design me the building and I promise to pay you $100,000. If you have designed the building and there is nothing more as to what you were supposed to deliver in those designs, other than you were designing me a new house, there's no more detail. if you design that house, I owe you $100,000. The clear and unambiguous language is always enforced. Second, no explanations or clarifications of the language is permitted. This is when I say you must stay within the four corners of the contract. So if we go back to the example of the design. If the design of the house, and that's all it says, you're going to design me a house, and I owe you $100,000, and I don't want to pay you the $100,000, I can't come back in and say, but we were supposed to have a 4-bedroom house, and they only designed me a 3-bedroom house. That may have been discussions that happened between us as we were talking about it, but if the written contract, which came later in time, and that was the last thing signed, if it just says design me a house, I cannot explain away what's outside of the four corners of the contract. Now, what ends up happening, obviously, is contracts for architects and contractors and everybody is a lot more complex and more detailed than that. And there's a lot more stuff that comes in. And so that's, again, the judge or the jury, whoever's the trier of fact, must still look to see clear and unambiguous, and they're not going to explain or clarify. You can't, like I said, so to speak, fill in the blanks if there are no blanks. And finally, why do you have this process of analysis? Well, it's to resolve conflicts and to confirm what the deal is. So, what are we going to do with that? Why do we want to? We want to make sure that the parties, when we're doing this, we're going to say, if there are conflicts, we have to go with the agreement between the parties. We can't take extraneous information. We can't pull what you all thought. Because if you think about that, if the parties enter into a contract, whether it's oral or written, but let's just take, because as I will say throughout the semester, any project you are ever in, whether you're a small mom and pop shop or you're working with a big company, get something signed in writing. Don't have an oral agreement, because then you have all these questions. So, if you're going to go to the trouble, though, of creating that written document, and you have the rules of the road of what I'm supposed to do for you and you're supposed to do for me, that mutual exchange of consideration, remember that from last week, the consideration? If it's spelled out in the contract, the courts must look at that, because if they have to start looking at all this extraneous information, everybody would be offering their opinions all the time as to what that document meant. And then that agreement, the value of that agreement, that written document you had, would be worthless. I mean, if you were allowed to come into court anytime, or to an arbitrator, or to a jury, or whomever, and say, I know the contract says this, but what it really meant was that, what value is it of that contract? So the law, and this is what the trier of law tells the trier of fact, the law says these three things when you first do your analysis. Clear and unambiguous, no explanations, and what was the exact deal that they agreed to on the four corners of that contract. Now, as I just finished explaining, there should be plenty of contracts where not every single piece of language is in there. Not every word is going to be in that agreement, because that contract would be thousands of pages long. And trust me, I do write contracts. I have a contract right now that I was working on last night. It's 487 pages, so it's a long contract. There's a lot of stuff in that. It's for a $690 million project, though. And in fact, because I'm a lawyer and we like to write and we're conservative and we like to protect our client, if we had our druthers, there's probably another 50 pages that our client has cut out because they think it's too verbose and too wordy and everything else. We probably add a lot more stuff in it. But, you work with your client as what they want, and that would ultimately. So there are long contracts. But the contracts we're going to go through in a couple of weeks, the B101, the owner-architect agreement, and the A201, I think the B101 is about 24 pages. The A201 is about 40-some pages, so they're not hundreds of pages long. And you can get pretty much what you need in that 20 to 50 pages of contracts, and those are used in about 75% of all construction contracts in the United States. So we don't have to have everything super long. But still, there's going to be things that aren't in that. So what do? What happens if the language is not clear and unambiguous? What if the language in the contract is silent, but the parties both agree that there was an obligation that needed to be performed? What do you do then? Well, then you go to what's called the second level analysis, and this is something called the parole evidence rule. Parole evidence rule, and just so you know, I'm going to go over the slide for you and explain to you so you have it future. You will not have any questions in the exam on the parole evidence, but I like talking about it because it's relevant. I can't promise there wouldn't be a question on this on the AREs, because I know they talk about stuff, and so I teach it. but it's relevant to how you guys practice. So I bring it up. It's not like, okay, we're going to do stuff in this class you're never going to be tested on. I think it's important because contracts are very important to what you do, and you need to know that they're not going to have everything. So what happens? So the parole evidence rule here is an explanation using facts, communications, or circumstances found outside of the language of the contract to help explain upon what the parties agreed. Pretty simple. If it's not clear and unambiguous, if it's missing in the document, then the courts can take testimony. They can look at evidence of what was happening in the field. They can take this parole evidence and actually use it to interpret the meaning of the contract. Okay? And parole evidence is only considered on the following circumstance. So there's these very unique times when you're allowed to bring in what's called parole evidence. And the first one is it's never permitted to alter clear and unambiguous contract terms. So if we got it, you can't change it. The court may say that the contract says X. People may testify about that at trial. You may get somebody on the stand, and then let's say it's the party who breached the contract, not the injured party, but the party who failed to perform. You put your contract manager, the person that negotiated the agreement, you put them on the stand, and there's a specific clause that is relevant to something that did or did not go right on the project. You're going to ask that individual on the stand, what did you mean about that contract? If I'm the injured party, I'm going to say, objection, Your Honor, the contract speaks for itself, the language is what it is, but the court may let that language come in. If that happens, I would then have the judge, present what's called a jury instruction that says to the jury, they may not consider the testimony of Mr. Putman about Clause A because Clause A is clear and unambiguous. It's a parole evidence, and the judge would instruct the jury to ignore that testimony. So, you cannot use it if it's clear and unambiguous. B, parole evidence is allowed if the contract is silent on an issue. So if something comes up, and we talked about, let's say there's this question about, whether there's supposed to be a 3-bedroom house or a 4-bedroom house, and the contract just says, no, you're just going to design a house. There may be a circumstance where the judge would say, was that a relevant and germane fact to this project? One would think it's a crucial fact whether you're designing a 3 or 4-bedroom house. And if there were discussions about that, the judge may decide, and the judge is the one that allows to determine whether parole evidence can come in. The judge may decide, you know what? Whether it was going to be a 3-bedroom or a 4-bedroom house seems pretty darn important. And the parties, I need to understand if the parties had an agreement on how many bedrooms this design was supposed to be, because the contract is silent on that. So I will allow parole evidence. I will allow testimony. But that silence, again, it's always more difficult to determine whether it can come in if the contract's silent, because you have to determine first, is that blank space, that silence, but the issue about it, is it relevant to the performance of the parties? My example of 3 versus 4-bedroom house, pretty important. But maybe it's whether whether you're supposed to use a certain type of brick or a certain type of fenestration or some other piece. Is that as relevant? You know, when you're designing, and those of you who've potentially worked on shop or technical drawings and the tech specs, sometimes you'll see the language, contractor can use this type of material or equal. You allow the contractor to use or equal because maybe the specific brick that you specify by a specific manufacturer isn't available, but there's an equal product. Well, in that instance, it's not, the contract says something, but it doesn't say exactly whether what is or equal. The court may or may not allow to hear parole evidence on that. And third, parole evidence may be considered if the contract is unclear or ambiguous. So the opposite of here. You're not really sure what that means. I'm not really sure what the language in the contract. So those things come up. Any questions on that? So that's your 2-level analysis. The first in almost in every case, well, in every case you're going to have is that first level. What's the contract say? What is the writing? Parole evidence comes in very rarely. If you guys remember the example I had last week, we had I think I gave it, maybe it was the first week, I'm not sure which. I had a case in Michigan where we had a a project where there was a contract that was heavily negotiated. We took probably 40 depositions, 30, 40 depositions, and we finally got the main guy, and we took his deposition, and there was a clause. And that clause in that contract, if the testimony went one way, it would be really good for them. If it went the other way, it would be really good for us. And the delta was about $8 million on how that clause was interpreted. And in the course of the contract, I always thought was clear and unambiguous. I thought the clause was very clear what it said, but they didn't focus on it. So in the course of all the depositions, not all of them, but a number of the depositions leading up, I would drop questions, not necessarily about this clause, but about elements relating to the obligations that this clause required the other party to do, how they were supposed to approve things, so forth. And then we got to the final deposition of this senior guy who was in the contract negotiations. And on his third day, I had asked him for the first 2 days, every once in a while I'd drop one of these questions and I'd say, I talked to Bob in a previous deposition, do you know him? Yes. He said you guys did A, B, and C. And he would say, yes, that's what we did. And I would establish, and I ended up locking him in on the company's position as to what this clause, what they believed the clause meant. And then the very last day, I put the clause in front of him, and I asked him to read it into the record. And as he read it into the record, he knew that the clause as written sunk him because of all the things that he and his other colleagues had been talking about. And the attorney to the other side objected and was stood up and everything else. And I'm like, counsel, I didn't ask him a question. I'm just asking him to read the contract clause into the record. And it was a switch because in almost every single one, not almost, in every other question I'd asked him about other clauses, I would read the clause. But for impact, I made him read it. And as he was halfway through it, he stopped and he knew. So his attorney objected, blah, 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 blah. And we went to move what's called summary judgment to win the case. And then we found a box of documents under the desk 6 weeks before trial from one of my client's employees. And that contract included writing on that very same page about that very clause. We objected to that evidence coming in by being of whatever it said in the margins of that agreement. We objected to that language as being parole evidence because we said the final version of the contract on which I had already gotten testimony that sunk their case was what was signed. And that language was clear and unambiguous. And his understanding of it was clear. He testified what he understood to it, even though he knew he didn't want to. And the language was clear. So we told the court, I know we just found this box of documents. We weren't withholding it. It was under somebody's desk that had actually left the company, and they found it when they were cleaning out his cubicle a year later when they were actually removing somebody in. And that was the true fact. But I know that there's this writings about this clause. But those are previous versions. They are parole evidence. They are outside of the clear and unambiguous language of the contract. Well, the judge was furious because he thought we screwed him over and we had to go to trial and everything else. So he did not rule on that parole evidence issue. He allowed testimony in during the trial, but because there was no jury, we ultimately found for us in his judgment at the end of the case. He said the evidence on that extra contract with the handwriting was parole evidence. And that in finding his decision for us, he ignored it knowing he was not allowed. So that's just an example of how it could work, of clarifying. Where we said it was clear and ambiguous, they said it wasn't, and they tried to use external language to prove that it wasn't clear and unambiguous. Okay, enough on that. Let's move on. Okay, next thing about contracts is express terms and implied terms. So in that contract, as we talk about, you're going to have lots of words and lots of obligations and everything else. And the ones that say, if I am going to design you a 4-bedroom, 3-bath house that will be between 2,500 and 3,200 square feet, that has blah, 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 blah. All of that in writing are express terms. So it's going to be in your contract. You are going to have express terms in writing, or they could be oral. Oral is just your oral agreement. But back to this parole evidence rule, if it's oral before it's in writing, whatever was talked about orally, it has to be put down in writing. If it's not, then we have to determine where those oral agreements, those terms come in. Okay. Implied terms are part of the agreement, but they are not discussed or communicated. So everybody knows that when you guys work and perform as an architect, you are going to be licensed. Some contracts say the architect must be licensed, but the AAA contracts, I don't know if they say you're licensed. But it's implied that if I hire you as an architect, or I go to a firm, let's just say I go to a firm that has 25 architects, I don't go and say to everybody on the team, are you licensed, are you licensed, are you licensed? What is implied in the agreement between the parties is that the drawings, when they are complete, are going to be signed and sealed by a licensed architect, because we all know you cannot build a building with drawings by an unlicensed architect. So that's an implied term. Okay, so as I say, some common implied terms in construction contracts. Neither party will hinder the other from performing the contract. And this is actually in all contracts. We're going to enter an agreement. You're going to do something for me, and I'm going to do something for you. And it's implied that I am not going to purposely stop you from performing so I don't have to pay you. It's implied that we're going to cooperate and get along. I'm not going to stop your design so I don't have to come back and pay, because I can say, you never finished your work. It's implied. It's not stated in there. Okay? The construction will be performed in a good and workmanlike manner. Now, you're actually going to see this language in probably almost every written construction contract, because it has legal definitions and implications. But it's important to know that if you have a construction contract, everybody knows or expects, it's implied, that that work is going to be done in a good and workmanlike manner. And then the third one here, architects, as I said, they will perform their duties in accordance with the appropriate standard of care. So, as a little nuance, the standard of care is what, and we'll get into this later in torts and some other provisions, but this is probably going to be the thing you guys will hear the most throughout your career when you start talking about what your level of performance are. The standard of care is an architect shall perform consistent with architects, professional architects, performing the same type of project in the same area. So it's a comparison across the board. Standard of care is, I'm not going to be perfect. It's what an ordinary architect will be performing for the same type of project in the same type of area. So, if you're a residential designer and you go out and you design a office complex, but you almost exclusively do residential projects, and if something's wrong with your office complex design, you're not going to be compared against your competition of residential architects. You're going to be compared against architects that do commercial work, because it's the same type of project at the same place, same location. Another thing is, if you're designing an office complex in Chicago, and then you get a project in Phoenix, you're going to be held against the standard of the people that do office complexes in Phoenix. So the standard of care, that's why it says it's the appropriate standard of care. It changes as to location and time and type of project. Any questions on that? Okay. A little different. I got another clip to show you. There's some express terms on this one. They're quick. You got to see them at the fast in the beginning, and then we'll talk about them now a little bit later. A little problem with my video. It'll come back in a second. I hope. There we go. Okay, so we have a contract here with Willy Wonka. Much better, I think, than the Johnny Depp movie. I'm a big fan of Johnny Depp, but I think his rendition of Willy Wonka was poor. But here we have a contract signed, and they all have their obligations. All of that, and granted, this started huge in the top and went smaller and smaller and smaller. Every single thing in that contract are express terms. And there was the question about whether you have some type of indemnity agreement, and Willie comes back and says, never amongst friends, and whether those comments are relevant in the ultimate terms of that agreement depends on what the express terms that are stated. What is on that wall and what the kids signed are the express terms of that contract. And if there was a problem with whether, in fact, either Willy Wonka or the children performed in accordance with the agreement, the trier of fact, maybe the Oompa Loompas, would be able to only interpret what the actual written words are. They are not allowed to go around and have the extraneous conversations that Mike TV may have had, or Ruth Assaults, or whomever. Now let me ask one question for you, taking from last week's. What's wrong with this contract? Anybody have an idea? Yes? Possibly. That's a good one. Anything else? It's pretty obvious. Think about it. Think about the contracts, what we talked about last week. They're minors. Excellent. Okay, one other nuanced thing that we talked about last week. If we all remember, and it was interesting when I was pulling this clip up and putting it into the lecture for today, there's a lot of conspiracy website theories about the whole Willy Wonka movie, which I had never known. I was like watching these videos of why people do stuff. But they all won the golden ticket. That's a unilateral contract. Because the agreement that Willy Wonka, the chocolate company, went out and said, if you find a golden ticket, you will receive a tour of the facility and a lifetime supply of chocolate. And all you had to do was find the golden ticket. That's a unilateral agreement. None of these children, minors or otherwise, needed to sign that contract because the promise had already been made. If you find the golden ticket, you will get a tour of the factory and you will receive a lifetime supply of chocolate. Now, the interesting thing is here, so if this came through and there was a problem with this and we had to enforce this, the first thing I would do as Charlie or Ruka's or anybody else's lawyer is I would say this contract is void because it never existed. As a minor agreement, you cannot enter into an agreement. I would also say, if I was trying to argue, let's say that he didn't have the children sign it, but in fact the parents signed it. So then it became legally binding. If I was Willy Wonka, I would argue, yes, your children all had a unilateral agreement. That's what the golden ticket is. But as soon as you signed this agreement, later in fact, you have superseded any previous writings in the past. And so Willy Wonka, again, had he had the right people sign it, could enforce it and say, forget my unilateral agreement. As soon as you signed on the dotted line, you are bound by those terms. So a couple of interesting things that I've heard had nothing to do with the movie, but I always find it kind of interesting when I think about it. Have you guys seen this version of the movie? Have you guys all seen this? Okay. The one thing that I found last night that was pretty interesting, this one guy came out and he was talking about what happened to the children. Some conspiracy theories thinking that the other four children, Augustus and Veruca and Byron and Mike TV, they all disappeared. You never know what happened to them. And there's apparently, I didn't watch many of these, but there's apparently signals or symbols throughout the movie that say these kids are made into chocolate bars and sold to the public, which is kind of gruesome. He actually said that, which is a little just as creepy as well, this guy's theory was, if you guys remember, there was Slugworth, the supposed competitor, and that he would come to each one of the children as soon as they got the golden ticket and said, you're going to get the everlasting gobstopper. And at the end, you have to bring it to me because I want the intellectual property, so it could be corporate stealing. And it was the test of whether the everlasting gobstopper was given to Slugworth, and we all find out at the end Slugworth actually works for Willy Wonka. The theory is that Willy Wonka did want to retire, he did want to give away his factory and everything else, but he had already picked these four children to show the most terrible of four of the seven deadly sins of obesity and the other ones that they have. And so that if you remember when they find the golden ticket, Slugworth is right there. Like, in fact, when Mike TV, his dad was a car salesman, Slugworth is actually washing the car behind him, and that all those golden tickets were pre-planted for these children, and that Willy Wonka knew that they were all going to go into these bad situations. It's a pretty interesting theory. It's nothing to do with our class today, but as I was reading this last night, and as they get on the different rides, they go from the wandering around where the Chocolate River is, and then Augustus goes away and he gets souped up by the river, and they get in the boat, and there's no room on that boat. If Augustus and his mother was there wouldn't have been a seat for them. That Willy Wonka knew that each room they went into, two people would be disappearing. Thought it was interesting. I've read the book. It's not in the book, but who knows. Okay, let's move on. Back to contracts. All right, so now that's just as far as interpretation of the contract, that's all you guys need to know. Basically, you've got to stay with the four terms, within the four corners of the agreement. We're going to try to figure out what the intent is, and if there's rules, you got to stay with clear and unambiguous. If it's outside of clear and unambiguous, you kind of go into something else. Next. Now we have these conflicts and contradictions and inconsistencies. Sometimes you might have terms within the agreement. They talk about the same thing, but they may be in conflict. What do you do with that? Or how do you deal with the inconsistencies of that contract? Okay, first, determining whether there's actual contradiction or consistency. That's the first thing we got to see is, do the words in the contract actually contradict? Is there some kind of inconsistency? So you may find, and here's an area where it drives us crazy. When we come in as lawyers and we start working for a client we've never worked for, they'll say, here are our form contracts. Scott, and it's probably been worked on by 3 or 4 different lawyers over the past 10 years, and everybody's added stuff, and maybe they're in-house people and everything else, and I start reading it, and I'll find clauses, like in Section 2, there'll be a clause on, say, indemnity. And we'll talk about indemnity later. And then in Section 4, there's another indemnity. And in Section 8. And you turn out that the concepts, for whatever reason, as this contract has been hodgepodge put together, are talked about in numerous places. And you have to read that document to make sure that they're consistent. It's not a problem to have the same concept being repeated over and over in the contract, but you need to be consistent with it. And if you aren't consistent, then the other side, to their benefit, will cherry pick. I like this interpretation of the contract better than this one, so I'm going to hang my hat on that. So sometimes that's where you get a dispute. I didn't think I had to deliver this on such and such a date. You said I have to deliver in a reasonable period of time. And I point to a provision that says, no, you need to deliver within 15 days. Well, I thought that meant about the delivery of this type of material, not the delivery of that type of material. I was just going by what's reasonable. I thought 15 days was unreasonable. So you get disputes over that. So you got to figure out, are those words inconsistent or contradictory? And then the next thing you want to do is there an interpretation, either a contract rule or a judicial rule, and I'll explain that in a second, that would allow the terms to be read consistently? So, contract rule is when you actually write the contract. In the contract, it will say, specific must be read in advance of general, or capitalized over non-capitalized. There'll actually be rules written to the contract of how you read the document. There are judicial rules also, like the parole evidence rule that we just talked about, or that the document will be construed against the person who drafted it. So that's some things. So what you do is you first look, and the parties are disputing over their obligations, and one party points to Clause A, another party points to Clause B, and you determine if they're contradictory or inconsistent. That's the trier of fact. And then if they are potentially inconsistent, is there some rule that we can look to see if they are, how we can make them consistent? How can we mesh? Now, so, rules stated in the terms of the contract resolve inconsistencies. That's the contract rule. One document may supersede another, such as specifications supersede drawings. So you're going to have the rules that'll say, written specifications must be first before your drawing. So you get a spec book, and it talks about the type of insulation, it talks about the wood and all the different types, the concrete aggregate, and then you have the drawings. And the drawings may have something written on it. It may be because, God forbid, in this day and age, you cut and pasted the wrong detail. You brought it in from a different project. So the rule in the contract says specifications supersede drawings. Or you guys know how many people here know what a change order is? So we got only one or two. Okay, so a change order, this is another thing where one might a document may supersede another. So a change order is this. In a construction project, you're going to design me the 4-bedroom, 3-bath house, and it's supposed to have all the bells and whistles and everything else. And you finish the drawings, they're sealed, everything's good, we all bless, we all think it's great, and we send it out to the contractor, and the contractor starts building it. Somewhere along the line, it may be an owner-driven change order where I say, I want 4-bedroom, 4-baths. Well, you guys haven't breached as the designer. You didn't breach any obligation because I never told you to do that. Contractor hasn't breached any obligations because he's got drawings for a 4-bedroom, 3-bath house. So I am changing the scope to add a 4th bathroom. You design that, you stick it into the drawings and the specifications, the contractor builds that. At the end of the project, that change, that order to change the contract, will supersede the original contract. Because the original contract was for a bedroom 3 house, the 4-bedroom 3-bath. The change order changed it to be a 4-bedroom 4-bath. Change orders can happen all the time. So in that instance, one document, the change order, will supersede the base contract. And so you'll see this level of order of priority in the contract. That's one contract law. Requiring a lengthy or more expensive procedure to apply. You may actually have language in there that says, we would rather you have a more lengthy process because you want something more carefully done than speed. Speed doesn't necessarily mean the best. Even though time is money, in this case you may have language that says a more lengthy than an expensive procedure should apply for details. Or you want to have, maybe there's contract language that says identify who has the duty to inquire about the inconsistency. In this instance, there would be language in the contract that says, if there is a question as to the intent or the meaning of the contract and the related documents, which would be the drawings and the specifications, we look to, and in the AIA documents it's called the initial decision maker. Most often that's going to be the architect. So the contract rules will say, if there's an inconsistency, we look to the architect to resolve that inconsistency first. So you may get a chance to come back in and clarify and clear up your stuff. So those are the 3 areas. Document may supersede, a type of procedure, or an individual who is going to be the one that actually is the person who clarifies the inconsistency. If any of these exist written in the contract, you use that up above to clarify, and that could be the ultimate answer to the case. So let's go back to our example. We have a contractor that says, I thought I would have to deliver in a reasonable period of time, and I'm making the example, you had to deliver in 15 days. One could make the argument that 15 days is specific over reasonable, so 15 days would control. That's one way of making an argument. The other argument I would say is, I'm the owner, I would say, Mrs. Architect or Ms. Architect, will you tell me what you meant by those 2 provisions? And she could come back and give testimony as to what they mean to help clarify any perceived inconsistency. And if that would be it, that the initial decision maker to the architect, she would be the individual who could clarify that. Does that make sense? Okay. Judicial rules. So remember I said there's 2 ways you can figure out how to do it. There's contract rules or judicial rules. Judicial rules is follow the specific rather than the general provision. You can have that written in, but it's also in the law. There's decades and decades of case law that says when we are generally interpreting contracts by law, we're supposed to look at specific over general. So you don't even need to write that in your contract. It can be there. Did you have a question? Okay, sorry. So you don't have to have it because the law is always going to enforce specific over general. 15 days over reasonable. The law is always going to look to the 15 days than the reasonable. Second, a judicial rule. Construe the contract language against the party who drafted it. So, now this is a little nuanced one because if you think about it, in most commercial enterprises, most commercial things, there's going to be a back and forth. I draft a contract, I send it to you, you review it, you send maybe make some changes, and there's a back and forth. And in those situations, the courts are not going to traditionally, are not going to look at one party or the other as the drafter of the agreement. Now, there are some instances where you can make the argument. Maybe it's a David and Goliath type situation, or it's a massive contract and it's just a little mom and pop and they didn't have the horses or the wheels to actually go in and even it out. And so there may be some language where the times where the court will, due to the bargaining power positioning between, will construe the language against the larger, bigger entity. Or if there's a situation where the other side, if the language is so favorable for one side, and it was drafted by the one side, the courts may say, I know you guys really want this, but if there are any problems with it, because it's such a one-sided provision, if there are anything wrong with it, I'm going to construe it against you. You had the chance to draft it. You drafted it. If you screwed up on it, you got to eat it. So that's where you construe the language against the party who drafted it. And then finally, another judicial rule in trying to figure out if there's inconsistencies and to clarify those inconsistencies is construe the contract as a whole. So how would that provision that may be not necessarily clear, without taking the parole evidence in, how would that provision work within the corners of the contract? What's the meaning? What's the intent of the parties? Going back to that general, what do you think the agreement was? Does that all make sense? Okay. All right. How about modifications of the contract? Can there be modifications? I just talked about one, this change order concept, and this is after the execution. So, the parties who sign a contract may always agree to modify the contract. Anytime you want to, the parties may agree. Now, you're going to see a contract that says, this contract may not be modified by any circumstances whatsoever. It can say that. It'll say black and white. This is an agreement. It supersedes all past agreements, and it can't be modified by either party, in oral or writing. And you will see clauses that say that. Cannot be modified under any circumstances, either orally or in writing. If the parties agree later on to change it, that clause is worthless. Because they've agreed at a later point in time to change the terms of the contract. So as long as they agree, they can always modify it. They can't modify it unilaterally, because you have to have an agreement on both sides. But no matter what it says in the contract, you can always agree later to modify it. Second, that's what it said, even contracts are forbidden to be modified. There could also be an oral modification of written contracts. So we go back to this Willy Wonka example where we had the unilateral contract of the golden ticket. And as I said, had Mr. Wonka actually had the adults sign that contract on the wall would have been an after-the-fact modification or a superseding of the original unilateral contract. Same thing can be with an oral agreement or an oral agreement modifying a written one. So we enter into a contract. It's in writing, the 4-bedroom, 3-bath house. It has all the bells and whistles, et cetera, et cetera. I'm going to pay you $100,000, and we have all that in writing. It's all spelled out in the 4 corners. And at some point later down the road, I come to you and I say, it's a little tight on cash. Can I pay you only $90? Is that okay? If you agree, yes, that's okay. We're doing well, and I know you're going to give me later business later, and blah, blah, blah. If you agree to take less money, that oral modification can change the terms of the written contract. It's an after-the-fact agreement between the parties. Now, obviously, your best bet is after we have that conversation on the phone and the price is reduced, you should send an email and say, concerning our conversation today, you agreed that we could pay you 90 instead of 100. Or confirming the conversation, we said we would pay you 100, but the second 10 won't be coming until 6 months after the project is completed, or whatever that modification is. The recommendation is whenever you orally modify a written agreement, somewhere put it in writing, but you can orally modify it. Timing of the modification, that's also important. It has to be, of course, after the contract's signed. That would be the modification. But then the question is can you modify a contract after the work was performed? After the obligation has passed, can you modify that? And it comes into, again, the agreement. Maybe you're allowed. Maybe you come back after the fact and the parties talk about it and say, look, we were supposed to do this. We were supposed to give you designs by January 1st. And if I didn't give that, you were worried that your project wouldn't be built on time. I got And me as the owner, I'm writing these emails January 15th, January 20th, where my drawings. If I accept those drawings on February 1st and there's this conversation, you're already in breach because the drawings are late. But if I accept them and we go through it and I say, yes, it's okay, then I have actually modified the contract after the breach has occurred, and that still is okay. But if I don't come back, if I accept them on February 1st, and I don't say that's okay, if I don't expressly agree to have changed the January 1st deadline and allow you to move to February 1st, simply my acceptance may not be a sufficient modification of the contract, because there may not be an agreement, and I potentially could still bring a lawsuit later down the road as to why I was damaged from that. So timing is important in how the modification is expressed.
Can you explain why modification is allowed for contract cases?
Which one? This?
Yeah.
That forbids it? Okay. So I have a contract with you. You and I have a contract agreement, and we put it in writing, and we both agree as we sit here today, no writing or any other modification can be made to this agreement. We both agree. We write it, we sign it, and everything else. And I'm supposed to deliver that documents to you by January 1st. And if I don't get them to you by January 1st, you're going to charge me what's called liquidated damages. We'll talk about those in a little bit today. Which is for every day I don't deliver you those drawings, you're going to charge me $1,000. That's our agreement, okay? So I know if I get you those drawings on January 15th, I'm going to owe you not only the drawings, but I'm going to owe you $15,000. We have that in agreement. And we write it, we sign it. And then I call you up on December 1st, and I call you up and I say, hey, I'm going to be late. Is that okay? When? I'm going to get it to you by January 15th. And you say, okay, that still works with me. And I say, am I going to be charged with liquidated damages if I come in on January 15th because I'm owed January 1st? And you say, no, you're not going to be charged with liquidated damages. We have now agreed to change the terms of the contract. And it doesn't matter that we said 6 months ago we won't change these terms because we changed our minds later. Everybody's allowed to. So the whole concept that even if it says it's forbidden, as long as the parties later, and it has to be clear, not only did I say to you, I'm going to be late, and is that okay? But I said, are you going to charge me the money, the damages? And you say, that's okay too, I'm not going to charge you. So we have now created a supplemental or a subsequent agreement that modifies the first written one, and that vitiates that, or removes that provision that says we can't modify later. Everybody's allowed to change their mind, as long as they change it and they agree on it. Does that help? Okay. Any other questions? Okay. Continuation of after execution of the contract. So there's reformations. What do you do? There's some legal ways you can do it. Legal issues as far as what you can do. One thing is called reformation. That's actually a lawsuit you bring. You actually ask for reformation. Reformation, so it's a legal remedy as opposed to the parties can just change. If we have a written contract and we change it later on, that's just a business transaction. And that then the court enforces that subsequent business transaction. This is where you actually go to the court. Maybe the parties don't agree with what happened on their own, and you ask the court to reform. So reformation is when the written terms of the contract do not accurately reflect the actual agreement reached between the parties. So you write down what you're supposed to do. We're going to design this space, and we're talking about the delivery date. And we've actually changed it, but we didn't put anything in writing. We've changed now that instead of January 1st, it's January 15th. It's an oral modification. And the parties went along with that. And the parties agreed. So the actual actions of the party, or what their original intent was, that's something that you reform. You change the language. Or maybe the writing in the contract wasn't clearly expressed as to what both parties agreed. So testimony at trial, both parties agree, we're going to do A, B, and C, and I agreed to do A, B, and C, and he agreed to pay me for A, B, and C. The contract may say, you're only going to do A and B. What you would do is, if you could say, we are asking the court to reform the contract to show that we originally agreed to do A, B, and C. This is not a very commonly used exercise, but it does happen from time to time. The lawsuit seeking reformation makes it the only time, that's the only time a court can rewrite it. You have to specifically ask for the remedy of reformation. And the reason why it's not used very often is if you think about it, most of the time you're going to go to court because you, as a result of one party breached, the other party's injured. So you're going to bring a lawsuit to say, I lost money or I lost an opportunity because the other side failed to perform. The other side's going to say, wasn't my fault, I performed everything I was going to do it. Well, that doesn't create an instance of reformation because right from the beginning, you're both disagreeing on what you were supposed to deliver. And the only time you're going to be able to get that reformation is you have to have clear and unambiguous and specific evidence as to what the contract and what the agreement originally was to show the court. And you have to show why there was an error in the document. It's a very, very high standard. So normally what happens is in those instances is you have other types of damage claims that we're going to talk about in a second, monetary damages. But it's the only time the court's allowed to come in and actually change the written terms of the agreement and say, it says this, but the parties both agree it really meant that. So that's the reformation. You have to have a good reason. You have to have a mutual mistake of fact is one. We're going to reform the contract. We were designing this space. We both thought that the place where the house was going to be designed was already zoned as residential. It turned out it was zoned as industrial. I still performed the contract. We all believed during the time that I should be able to do that. I drew this 3-bedroom, 4-bath house. I should be paid my $100,000. They thought it was going to be residential. We thought it was residential zoning. We want to reform the contract that it's just a delivery of a 3-bedroom, 4-bath house, 3-bedroom, 4-bath, a 4-bedroom, 3-bath house, and that it doesn't matter whether the party could actually build it there or not. There isn't the subsequent obligation because there was this mutual mistake of fact. So they're going to reform it. Sometimes they're going to reform the contract in case there's fraud. So Charlie Brown wouldn't be out here because he could make the argument that there was a agreement, even though she says there was not a notary and it was not proper, because there's an argument that Lucy defrauded Charlie Brown. The court's going to reform it and say the agreement was, signature or not, you were going to keep the football and he was allowed to kick it. Now there can also sometimes be a unilateral mistake, but you need to show that the other party knew that I didn't understand. So if we go back to the example of I'm designing a house for you, I believe the area where I'm designing it is going to be zoned for residential. You're the owner, you know it's not zoned for residential, you know it's commercial. You're working with your alderman to try to get the zoning changed. And we're in the process of doing it. I do the drawings, I present them to you, and you say, I'm not going to pay you because I can't build this house here because it's zoned commercial. I would ask for a reformation if I can prove, even though it was a unilateral mistake, that you knew I thought it was only residential. So I have to prove my unilateral mistake was known by you, and then I'll ask for the court to remove any obligation of zoning as to whether I should get paid for the contract. It's a reformation of the contract there. Does that make sense? Okay. Okay. So we've talked about how we figure out what the contracts mean, how do we read them, what do we do to interpret them, how do we clarify if there's inconsistencies. Now we're going to talk about if there is some kind of breach, whether it's due to inconsistency, failure of performance, or everything else. Now you got breaches. So what happens with the breaches, and then ultimately how do we get paid or how do we get remedies for those breaches? Okay. Why do we have remedies? Well, it's to put the innocent party or the injured party in the position he or she would have been in had the contract been fully performed. You want to be made whole. That's the basic goal here. As we entered into a contract, we should be made whole. I designed something for you. You were going to pay me. If I do the work, I should be made whole for being paid for my work. It's trying to, the reason for remedies is to put people back where they should have been. Contract remedies are not about punishment. In fact, if a contract has a clause that's considered a penal in nature or punishment, that clause is considered void. The courts will strike any penalty provisions in a contract. Now, there's a type of damage that we're going to talk about in a later slide called liquidated damages, and that sometimes can be construed to be a penalty. And so when you actually write up your liquidated damage clause, you say, this clause is a liquidated damages and is not intended to be a penalty. And that's the argument that both parties agreed that this is penal in nature. But remedies or damages that people recover when there's a breach of contract cannot be by nature punitive. One tiny exception if there's fraud. Sometimes you get punitive damages for fraud. Okay. So, there are different types of damages. Expectation, reliance, restitution, and specific performance. We're going to go through these different types of damages you can recover. The first are going to be monetary damages. Here we're having expectation damages. This is by far the most common type of damage that you're going to have in any contract issue, and certainly most common done in construction matters. Okay? The expectation is to making the innocent party whole as if the contract was fully performed. So back to that original goal of why we have remedies. What the expectation damage is you recover the difference in cost to complete the contract by others if the original had not been performed. In fact, you get what you expected. So let me give you an example so you can think about it and put this into context. You're a contractor, and I come to you and I say, here are the plans for my house. This wonderful architect over here has designed me these beautiful drawings and the specifications. I'm going to give it to you and two other contractors. Give me a bid. How much is it going to cost to build the house? You end up winning the award, and its cost, and your contract for me to build the house is $600,000. The other two bids were $750,000 and $850,000. So a significant difference between the costs. But I went with you because I had good recommendations, and by far you were the lowest bidder. You start to build my house because I expect you to do it for $600,000. At some point in time, you either go bankrupt or there's problems and you've done things on the projects and you are either failure to perform, you stop work, or I have to terminate you because you've breached other provisions. You have drug and alcohol on the projects or it's unsafe or whatever reason. But at some point in time during the course of the project, maybe you're $500,000 into your payments, you are no longer on the project and I have to hire someone else to finish it. When it's all said and done and completed, it costs me $800,000. I paid $500,000 to you and I paid $300,000 to the follow-on contract to complete. So I have now expended $800,000. You are in breach because of whatever reason, you've been bankrupt or you failed or whatever. So I would sue you for my expectation damages. And what I expected was I expected to have this house built for $600,000. I paid $800,000. So my expectation damages is $200,000. It's the cost difference to complete the contract if others to completed it had the original party performed. I always expected to only pay $600,000 for this house. So no matter how much it costs, if you are in breach, I only have to have paid $600,000, and any dime over $600,000 is my expectation damages, because had you performed it like you promised, that's all I would have paid. Does that make sense? It's a math problem, and sometimes they get a little complex when you're in construction because there's puts and takes and everything else, but ultimately it goes back to what the original agreement was. What did the parties expect? Here are the drawings. You build me the house. I pay you $600,000. If there's a difference between those, expectation damages mean I get the money back. I get more money back from you. Okay? Any questions on expectation? Next, reliance damages. They're awarded to an injured party who foreseeably relied on the promise. Sometimes even it's unenforceable. Foreseeably relies means I make you a promise and you think that my promise makes sense. That it was a valid promise, that you believed me, and it was foreseeable for me, the party promising you, that you would go ahead and honor my promise. And then if I fail to perform on that promise, because you relied on my promise and it was reasonable, whatever damages you suffer from relying on my promise, you can recover. So that's what it says here. You acted because you relied on the promise. And you get what you deserved based on the promise. So here's an example. My example here is, you're looking to buy a car. You come to me, you don't have the money and everything else. You say, I found this car. And I say, if you can buy a car that what you need for up to $10,000, I will pay for it. And we have a relationship such that makes sense that I would pay you for that. It's reasonably foreseeable that I would perform in that promise. And you go out and you spend $9,000 and you buy a car. And then I don't pay you. Do we have anything in writing? No. I was just kidding around. I don't know if that was an agreement. Prove it. You don't have anything in writing. Prove that I was going to give you $10,000. Whatever it is, your lawsuit is going to be on a reliance claim. You're going to say, I relied, and it was reasonable for me to rely on you, writing or no, that you would reimburse me for a car up to $10,000, and you would be able to recover for me the 9. Not the 10, even though I said you could buy it for $10,000. Whatever your cost was, your reliance on that. That would be. It's also about my money back type concept. Because, in fact, you spent your money on this reliance. I want my money back for that promise. I would have never gone out and bought that car had you not promised me that. I want my money back. So that's what a reliance claim is. Now, sometimes reliance can be as you relied on the party selling you the car was valid. I went and it was a used car. It wasn't that you got a promise from somebody else. It wasn't that somebody else was going to pay for it. You came out money out of your own hand, and you go to the person selling the car and you say, how does the car run? Have you had it tested? Are the brakes good? Are the pistons good? Whatever it is. And they say, yes, 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 yes. You are relying on their representation. And you spend the money, you buy the car, and it turns out the brakes aren't good. So you can go back and you can say, I want my money back. Here's my car because I relied on you and the reliance was reasonable. I want my money back. That's reliance damages. If you went and got the brakes fixed, and you had thought the brakes were new and you went and got them fixed and you spent $400, you could sue them for expectation damages because you expected that you would get a car that had good brakes. So you're supposed to pay $9,000 for it, but you spend another $500 on brakes, you're allowed to recover that $500 as expectation damages. So that's the difference. On reliance, you get your money back, here's your car, I want my $9,000 back. Expectations is I keep the car, but I had to spend $500 on brakes. You owe me $500 because you promised me something and I expected it. That's the difference in those concepts. Any questions on the difference between reliance and expectation? Okay. Restitution damages. Restitution damages are awarded to one party that has provided a benefit to another, and the first party has paid for that benefit. It's like an unjust enrichment. Think of a good example. Okay, so here we have is provided for. Here's an example of the house burned down mid-project. Okay, so you come to me and you say, I want you to paint my house. I want you to paint it all. Okay, I'll paint your house for $5,000. Great. Sign a contract. Start painting the house. I'm halfway through the project. And due to no fault of mine, nor you as the owner, the house gets struck by lightning and burns to the ground. My restitution damages are, well, clearly I haven't completed my contract. My contract was I would paint your house, but I only painted half of it. But I actually performed services. You're going to say, but I got no benefit out of your services. My house burned to the ground. So long as the damage to the house and the house burned to the ground was not my fault, I should get restitution for the services. In fact, I performed something, and maybe not forever, but it wasn't my fault. You were unjustly enriched. You received the benefit from me. Granted, the house got burned down, but that's not my problem. You got the benefit of me working, so you owe me, because I painted half of it, $2,500. Restitution damages are to recover when someone benefits, even if the full contract wasn't performed. So a little different. You're not allowed, the other side is not allowed to get a windfall from the services you provide. Let's say I'm I sell oranges, and I'm going to sell to you guys in Europe an orange juice company, and I deliver a number of oranges to you. And you get there, and they come to you, and for whatever reason, there's an accident, and the delivery truck, after the oranges are delivered, you have them in the house, and then there's an accident in your factory burns down. Well, again, not my issue, because I should get paid for the delivery of my services, the restitution, even though you weren't allowed to finally go to market with orange juice. Whatever the interim problem that happened between, I should get paid for whatever I had delivered. Maybe I only delivered 1 out of 3 sets of trucks, or whatever it is. The contract was not fully performed, but I get paid as a restitution for what I got to do here. So you are not unjustly enriched, and I'm not to my detriment. Those are restitution damages. So we have expectation, reliance, and restitution. Those are your 3 main monetary damage claims. Okay? Now there's sometimes where you cannot get a remedy for money. Sometimes money isn't the best thing. Sometimes you don't want money for it. You want the actual performance. These are then what's called equitable remedies. So you're not suing for monetary damages, you're suing for something to happen. The first type of equitable remedy here is what's called an injunction. You guys probably have all heard about quartering, going in on an injunction, everything else. An injunction is to stop something from happening. There's no financial gain for it. The court comes down and makes an order to stop something from happening. I'll give you an example of what happened for me in one of my cases early in my career. So when I first started out, I represented almost exclusively architects and engineers. And I had an architect that came to me and they said, or it was actually a design branch of a major lighting company. There's 6 or 8 major national lighting companies out there. They came to me and they said, Mike, we put in these lights and we worked with the architect and we're not getting paid and we have about a $400,000 bill between our architectural services and everything else, and we ended up getting terminated. They didn't like us. We're not complaining necessarily about the termination. In fact, they were a difficult client. We just want to get paid for our work. And they were owed about $450,000. The other side took the reflected ceiling plan of the drawings that we had given them and had taken the title block off of the drawings and put a new architect's firm title block on. We just used the reflected ceiling plan only for this because it was exact. They made some changes to some of the other designs and some other issues, and we didn't want to get into it. And I brought a copyright infringement action against the owner, not the architect that the owner hired, but the owner. That the owner had taken my client's drawings and infringed on those and were infringing on the copyright that we had on this reflected ceiling plan. And here was it, and you just laid them over on top of each other, they were exact. And I said, these are our protected documents, and I moved not for breach of contract to pay us the $450,000, because that would have taken 2 years and depositions and lots of times. This client wanted its money and they wanted it now. And so what I did is I went out an injunction to stop the project because they were infringing on the copyright, which is a very powerful tool. We'll have discussions throughout the semester about your intellectual property rights and how powerful those are. But we went to court and we got an injunction, and the court shut down the project because the client was it was a preliminary injunction, because then they were going to hold hearings and everything else to see if we showed the drawings at the hearing, but later they'll do a preliminary injunction, then they'll do a full injunction. We went on a preliminary injunction to stop a TRO, stopping the project on the evidence space before them. And as a result of that, We got into negotiations with the owner because not only did the court stop the installation of a bunch of lights in the ceiling, stopped the whole project. Because the court said, well, I can't tell which is which, and there's electrical that comes in, and there's all these other HVAC that comes into the ceiling. There were so many other systems that were impacted that we shut down the entire project. And the owner immediately, within 2 weeks, paid us because even though we had never sued for the $450,000, we just sued to stop the project on an injunction because they were going to lose more money with a bunch of workers sitting around and paying the contractors all this money and potentially a lawsuit with their own architect and everything else, that it was cheaper to pay us. So instead of bringing a lawsuit for expectation damages, we perform these services for you. You owe us $450,000 for performance of the services. That's expectation. We sued them for an equitable remedy, no dollars asked for, and we shut the project down to negotiate the money. So that's an injunction. Stopping something, an example you can do is in construction. Rescission. Rescission is undoing the contract and returning it to pre-contract status. I think I talked about a week ago, or maybe I can't remember if I did or not. I had a situation where a client bought a home, and the home was in a fairly new subdivision. It was at the end of a cul-de-sac. Did I talk to you guys about this? I know I talked about this recently. It may have been another quick lecture I gave. So, client bought a house. It was a subdivision recently developed, but they were the second owner coming in. It was at the bottom of a cul-de-sac in a brand new subdivision. And it turned out, when we moved in, when the client party moved in, it looked fine. Everything was fine. They did an inspection and everything else. But within 6 months, there was lots of flooding in the basement. And they started talking to my clients who bought the house, talked to the neighbors. And the neighbors had told them, yeah, we always are having flooding issues here because the developer didn't do the proper civil work, and so the drainage systems didn't happen properly from the overflow from the sewers into the retention pond where the water is supposed to overflow. Well, clearly the people that we bought the house from, they were only in the house for about 8 or 10 months. They said they were moving to another state. They had 2 houses, blah, blah, blah. They were moving out because the house leaked, and they didn't want to spend the money to fix it. My clients didn't have a contract with the developer because we were the second purchaser, so the only party that we could sue was the party from whom we bought it. And it was going to be more difficult for us to necessarily fix it to get our expectation damages, because we would have had to spend money to fix it. Let's say the client bought the house for $500,000. If they had to spend $100,000 to fix it, they could sue for expectation damages. I expect to get a working house for $500. I spent another $100 to complete it, so you owe me $100. That would be expectation damages. Now, in this instance, instead of asking for monetary damages, the client said, I don't want to live in this house. I could fix the flooding, but I have no idea how much mold is up through the walls. And we have allergies and everything else. This whole house could be toxic. We just want out. They knew. They lied to us. They defrauded us. So we went back into the court and we asked for rescission, an equitable remedy. Your Honor, we don't want any money. We don't want a dime except for our $500,000 back. We want to give them, they can have the house back. I don't care what they do with it. We don't want the house anymore. We don't want title. We don't want responsibility. We want our money back like the contract never occurred. You are rescinding that contract. So that's an equitable remedy. Now, the result of it, of course, we got our money back. But the rescission is you actually move like the contract had never been executed because it was fraud. Okay? Specific performance. Specific performance is another equitable remedy, non-monetary. It means the court comes in and says, the parties agreed to A, B, and C. I am going to enforce to make sure A, B, and C occurs. Now, it can never happen for performances of services. That's one place. So if I promise that I'm going to perform something for you, let's say, I think I talked about last week, I was going to come in and I was going to be an actor in your project, in your movie, and I decide not to perform in the movie. The court can't force me to be in the movie. That specific performance, the reason why as a public policy that's indentured servitude, even if you're getting paid, you can't be forced to perform services. So never specific performances for services, but it can be for something unique like land. Let's take the opposite of that party, my client that didn't want to have the house. The opposite is, I bought a house, or I thought I bought a house, and there was a bidding war between me and another party. And we end up agreeing to this house, and it's for $500,000, and we sign the preliminary contract. And before everything's finalized or what have you, before the money's exchanged, the homeowner finds someone that wants to pay $700,000 for it. And they sign that contract and they void our contract, knowing that there's a potential that there'll be a lawsuit and all the hassles, but they think they're going to make so much more money, a $200,000 profit, that they think they'll be able to buy us out for cheaper. I could sue for specific performance because I'm going to say land is unique. We want it to live here. So the court will enforce the contract if it was valid and signed first. What's called specific performance. So, 3 types of equitable: injunction, rescission, and specific performance. Any questions on those? Non-monetary, they ultimately probably result in a monetary payout or some type of thing later, but the court's order is only about forcing something to happen, either stopping an injunction, rescission, eliminating the contract like it never happened, or specific performance, requiring the performance of the agreement. Make sense? Okay, let's revisit our kids for 1 second here on specific performance.
I am extraordinarily busy. I just wanted to ask about the chocolate. The lifetime supply of chocolate. For chocolate. Well, when did they get it? Why not? Because you broke the rules. What rules? We have seen your rules every time. Wrong, sir. Wrong. Under Section 37C of the contract signed by him, it states quite clearly that all offers shall become null and void if, and you can read for yourself in this automatic copy, I, the undersigned, shall forfeit all rights, privileges, and licenses herein and herein contained, etc., etc., thanks, maintenance, infinity, and glory, and health, etc., etc., middle fifth, unit of your account. It's all there, black and white, clear as crystal. You sold this thing. You open it, seeing without it being washed, and sterilized so you get nothing. You lose. Good day, sir.
Okay. So here, Charlie's grandfather was seeking specific performance. Hey, I had the golden ticket. Or Charlie had the golden ticket. And you promised the lifetime supply of chocolate. So that was what they were looking for. Where's the performance that you promised, specific performance? They didn't want any money. They just wanted the delivery of the promise. Now, of course, we've seen Mr. Wonka goes a little crazy and says, you've already voided the agreement, you breached your contract with us, blah, 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 throws out words that don't mean anything. And at the end of the day, to say you have, as yourself, you have failed to perform under the contract, and as a result, you voided any obligation that I, Willy Wonka, or the company have to provide you with the lifetime supply of chocolate. Now, we've already established that contract is void, and so Grandpa and Charlie could just laugh in his face and say, give me the chocolate if they wanted to, because that contract doesn't count. But again, had the contract actually been entered into by Grandpa, by an adult, then Willy Wonka would have been on valid grounds to say, this contract superseded the golden ticket, and any obligations that I may have are bound by this contract that was signed, and your actions, by going in the fizzy lifting room, blah, 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 voided any obligations I have to perform, and the court would then find in favor of Willy Wonka, again, if the contract had been entered into the right party. Another interesting point in the conspiracy website thing that I saw was that they said Willy Wonka here actually used this as a test. It was the final test, because if you guys remember, if you've seen the movie, at the end, they're walking out, Grandpa's furious, and then Charlie puts the everlasting gobstopper on the table of Willy Wonka's desk to give it back instead of giving it to Slugworth. And in fact, that is the test to show that Charlie is actually a good and honest person, and of course rightful and deserving of not only getting the chocolate, but getting the entire factory and taking over for Willy Wonka. And that the contract, Mr. Wonka knows is impossible. It doesn't matter. It doesn't matter. The contract has nothing to do with anything. He knows it's an invalid and void contract. Now, this conspiracy theory this website didn't go so far as to say that he knew the contract was void because it was minors, but it makes the point that the contract has nothing to do with anything, none of the obligations. They even point out the fact that when Charlie and his grandpa were in the fizzy lifting room, that was when Veruca Salt was about to be taken away by the golden eggs, and he was in a different room, and how would Willy Wonka even know about that? But independent, the contract here is a vehicle that they're using, that he uses as a negotiation tool. It's something, not to say that I would make recommendations to anybody enter contracts that are void, but sometimes contracts and elements of it are negotiating points. Like I said, and you don't have to use, you can use elements of contracts to negotiate a settlement here. You can use promises that are made, something like a copyright law you can use. So when you're out there and in business, you want to use and think about pieces and elements of whether it's negotiate agreements or contracts or whatever it is as your bargaining chips. That's the other element here. You just kind of think about what you use it for and how you use it. Okay, so let's talk about, there's a couple other types of damages here that are legal in concept, but they are monetary. So they're not equitable relief, and they're not a type of either restitution or expectation. They're just a category of types of damages you can recover. So you could get, they're right here on this page, we have consequential and liquidated damages. Both of these are typically or traditionally considered to be expectation damages, just so you know. Consequential damages are what's called indirect damages remotely caused by the breach, but they must be reasonably foreseeable when the contract was formed. Okay, so let's talk about our example that we've been going here throughout the time. I hire you to design me a house. I'm going to pay you $100,000. At some point in time, you deliver those drawings to me, and I don't pay you the 100. I don't pay you anything. You arguably have, if the consequential damages have not been waived, and this point here is traditionally waived in construction contracts, but if there is no waiver, there's an argument to be made that says, not only do you owe me the $100,000, but I turned down 2 projects where I would have gotten a higher value. Or your project lasted longer than we both expected, and so I lost other projects. So I suffered lost profits in addition. In addition to doing the work that cost me $100,000 worth of my time and money that you owe me for, I had other damages that were a consequences of your failure. Maybe what happens is, the reason why I'm not paying you is because the project, your work was supposed to be done in 6 months, and I slow play it, and I extend it out, and it takes 8 months because I'm not going to pay you. And during that additional 2 months, you've lost other projects, you've lost profits. That's a consequential damages that you could recover. So that's one reason why you can get something more than just what's in the 4 corners of the contract if it's not been waived. So consequential damages are as a consequence of the breach, but are not identified in the original agreement. Lost profits, lost business, those types of things. But in order to recover it, 2 things have to happen. 1, it can't be waived, which is almost always in construction contracts. And 2, they have to be reasonably foreseeable. If you guys turned down a project where you would have gotten $1 million fee, and yet you were traditionally doing projects where in the $100,000 to $200,000, it would be unreasonable for me to believe that if you failed or did not accept that other commission because you were working on my project, that would have been a consequence. That damage would not have been reasonable that I would also gotten hit for another $1 million. That lost profits or lost business. So, has to be reasonably foreseeable. The party has to say, well, it makes sense. Can't be waived, but it can be something that is a consequence of the breach. Second, and this is what happens often when you waive your consequential damages, you get what's called liquidated damages. Liquidated damages is where the parties say it's a per day or per week, it's a unit value, where the actual damages would have been difficult to prove later down the road. A lot of times you do this in delay projects. The language must say this is not a penalty, liquidated damages, and say the following liquidated damages agreed by the party are agreement but shall not be construed as a penalty, blah, blah, blah. The value of the per day amount must bear some reasonable relationship to the actual damages that could occur. And the value per day must be calculated in the beginning. So let me give you an example to put this into context so you understand. It happens more often with contractors in the construction world than with architects. So I come to the contractor and I say, here are drawings, my great architect, I'm a candy company. And I need to make sure that my factory, my candy factory, is up and running and performing by August 1st because we're going to hit Halloween and Christmas. And that 4-month, 5-month period is my year. You know, sure, I could sell a few chocolates on Valentine's Day, but I'm not really selling much on the 4th of July. I make my money on Halloween and Christmas. And if my facility is not up and running by August 1st, I'll be behind the curve because I got to get out to distributors, I got to get my contracts in order and everything else. So I'm going to be hurt. If the project comes in late and I have not waived consequential damages up here, I could argue that all of my lost profits for not selling the candy during Christmas, Halloween and Christmas, I could try to recover consequential damages. Look at all the dollars because you knew that August 1st was important, and I'm losing all this money because you didn't finish the project until November 1st. I've already lost almost all the seasons. That's if there's no consequential waiver. But if they waive that, then I, as the candy company, am going to try to do something called liquidated damages. What I'm going to say is, while we sign the contract, I'm going to say, for every day that you are late in delivering and finishing my project, if the doors are not open after August 1st, you're going to pay me $5,000 a day. And they're going to be like, well, where'd you get that figure? Well, it's part of my lost profits. I'm not making any money. I've hired people to work, and I got to start to pay them because I thought they were going to start working August 1st because I got to start interviewing them in May and June. And they're expecting to start working August 1st, so I'm not going to screw over my workers and say, you don't have a job. I got to pay property taxes. I got to pay the mortgage on the property. I got to pay my construction loan. I've got utilities, because even though the building's not finished, there's still power going, and electrical and water, because you're close, but you're not finished. All of those categories, when you add them all up together, is going to be, as I sit here today, before you have ever started to dig a hole in the ground, somewhere around 5,000. Maybe 4,000, maybe 6, maybe 2,000, somewhere in that reasonable range. And we agree that for every day past August 1st, you owe me $5,000. That is what a liquidated damage is. It's not a penalty, even though we're saying because you're late, you have to pay me money. It's not a penalty because I probably would have suffered those actual damages later. But I don't want to go through the brain damage in August and September of calculating my per-day costs. That will cause me to spend money to pay an accountant and a lawyer and all this other stuff. I don't want to have to do all that paperwork. We're going to agree before the contract is signed on a per-day value. Happens all the time. Sometimes I do a lot of residential. So let's say that I'm going to be doing a condo building or apartment building, and it's 10 stories. What normally happens is the developer, the owner-developer, will try to get the lobby and the first 3 floors and maybe the penthouse done and get that money start flowing right away. And they'll do them in blocks. So 3-floor block, and then another 3-floor, another floor in the penthouse. And so you may have liquidated damages. If you don't get the first tranche of units done, you get a liquidated damages of $10,000 a day for X number of days. And then the schedule says the next 3 floors of buildings will be done a little later in the schedule, and then you're going to get hit for those liquidated damages. And if you still haven't furnished the first 3 floors and the new second 3 floors, now you're getting double. So it may be 10 and 10, it may turn to $20,000 a day. So those are those types of things where you have to calculate the cost. So the owner says, this is what I think it's going to be for every day you're delayed. That's what a liquidated damage is. Some of the projects I work on, the big, large projects that are in the hundreds of millions, those liquidated damages are somewhere up to between, the largest project I've ever had was $400,000 a day. And it was an energy company because they supplied electricity for thousands and thousands of homes. And in fact, the $400,000 per day would not have made my client whole. Because if my facility, the power plant, wasn't up and running, not only would they would be losing revenue from the customers, the homeowners that were paying for the electricity, But my client would have had to have, because they have obligations to the state, would have had to have bought energy from a competitor and used their excess power to make sure that the grid was all correct. So even at $400,000 a day, my client was losing a significant dollar figure. I had I didn't work on this project, but I worked with an expert. He was on a project building a casino. The liquidated damages on that casino was $1 million a day, because the revenue they generated on slot machines alone per day on opening the doors was in excess of $2.5 million. Per day that casino generated $2.5 million a day on just the slot machines. And so the contractor, for every day they were late, owed the owner $1 million. So the owner was losing money still, but that was the liquidated damage. And the project was late. It cost the contractor like $40 million. So, because they were like 2.5 months late, they negotiated down to $40 million. So they can be huge. In most projects, they're going to be, 1,000, 5,000, 10,000, somewhere like that. But I have seen LDs in up to $1 million a day. Okay. Those are types of damages. Consequential, liquidated damages. They are an expectation because you expected the party to perform. Punitive damages. Now, I said in the very beginning, damages in contracts are not about penalties, but as I said for the very first day in the class, probably the most repeated term you're going to hear me say in this class, and especially if you ask me questions, is, well, it depends. So even though I said they really don't want to have punitive penalties in contracts, well, it depends. Here, like I said, it's almost never awarded here, but sometimes in case of fraud. Charlie Brown could potentially go after Lucy, not only for breach of contract, not only for the personal injuries that he suffered because he relied on her not to pull away, but he could potentially get her for fraud. Not to make Charlie and Lucy and Charles Schultz kind of the bad guys here or anything else, but as an example, she defrauded him because she always knew she was going to pull the football, and she induced him to sign that contract with that fraud, and as a result of that, commercial transaction, he could get her for fraud. Punitive damages are similar to paying a criminal fine, so sometimes you hear somebody go to court and have to pay a fine that goes back to the state. Well, in this case, the fine and the penalty is paid to the individual that's injured. So I had a case this summer. We ended up resolving it. My client was charged they manufactured a pump for a wastewater distribution facility. It was basically processed human waste, and the pump was supposed to pump the human waste and other waste products out and to clean it. And there were problems with the pumps. We were sued for fraud. The fraud claim was bogus. We were able to defeat that. But they were claiming their actual expectation damages would have only been the cost to replace the pump. It was a $200,000 pump. Ours was like $160,000. They replaced it with a $200,000 pump that worked. So their expectation damages would have only been $40,000. That's all they would have recovered. They were suing us for $1.5 million because they had all these other costs involved and all these other things, and they were saying because of our fraud, they were entitled to get much more than their expectation damages. As I said, we resolved the case and we defeated the fraud claim, and so that was good for my clients, but that was the theory on which they said we get a lot more than their expectation damages of the $40,000. Legal fees is another type of damage you can get out of a contract. They're generally not awarded unless the contract specifically states it. So if you're ever in a situation where someone says, I'm going to come after you and you're going to have to pay my legal fees and blah, 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 if it's not in the contract, they're just making noise. But if it says in the contract that the prevailing party shall be entitled to legal fees and costs, then you potentially are on the hook for that. And those are the costs that they incur by paying their lawyers to resolve the claim. As a reality, legal fees are rarely awarded even if it's in the contract for the full value. So I had a lawsuit that we had, this was when I mentioned in Michigan. We won the case. There was what's called a prevailing party legal fee provision, which means the party that wins gets to recover their legal fees. Both sides had claims on either side. They were suing us for stuff and we were counterclaiming for them. So we both had claims. The big claim that they had against us, we defeated, but there were some minor ones that we did not. Our big claim against them, we prevailed on, but there were some minor ones that they defeated. So when we got down to the legal fee provision, we submitted a claim for $1.3 million in legal fees. And we sat in front of the judge, because that doesn't go to the jury, it goes to the judge in this instance. And the judge got us into a room and he said, "Counsel, well, first of all, I just want to say it says reasonable legal fees. I've never met a lawyer that has reasonable fees." So he told us right out of the box we were not getting $1.2 million. It just wasn't going to happen. Because that's his right. He's the one making the decision. And then he said, "I just want you guys to know, prevailing party is also at my discretion, and you lost some and you lost some, and they won some and you won some. So what do we do about prevailing?" And we had a long and hard discussion about it and went through it. And I cannot remember, as I sit here today, whether we agreed on a figure or the court said you are going to agree on this figure, effectively ordering it, but we got a significantly smaller amount by many, many percentages of our legal fees. So even though, just so you guys know, if you're ever in a situation where somebody says, "I'm going to get my legal fees from you," A, if it's not in the contract, they're making noise, and B, rarely, if ever, do you get they get full freight. 50%, 30%, those are the numbers you're going to hear. Sometimes you get full amount, but not always. Last slide. Mitigation of damages. So we've been talking about the entire time today the situation from the perspective of the injured party. What can they recover? How do they recover? I'm the one that says what this contract means, and I think that I disagree with them, so we need to figure out how the contract is interpreted. What are the type of damages I want to claim? It's an expectation or reliance or restitution. All of those are from the perspective of the party who's injured. Well, every lawsuit has two sides. So the party who has been accused of breach, in addition to their defenses of saying, "I believe the contract means this," or "I performed this way," "I didn't do it," "I performed as I was required," all of those defenses as to the factual obligations that the person called the defendant is going to assert. They also will say, even if I screwed up, I shouldn't have to pay him this much money because they, the injured party, have an obligation to mitigate their damages. The breach by one party, does not guarantee a recovery or full recovery to the other party. If you are injured, it doesn't mean that you necessarily get any money. Even if you weren't necessarily at fault, you have an obligation on your own to mitigate your damages. The non-breaching party, in this case the injured entity, must take steps to minimize its own damages. So as the defendant, I'm going to assert you didn't mitigate, you didn't minimize your damages. This can be a huge issue in construction case. And the injured party cannot take advantage of the fact that the other party breached. So here's an example. I'll give you two examples. I'm in a construction project, and I terminate the contractor. And there's a bunch of steel that the contractor has purchased from a steel supplier, a subcontract. And I just say to the contractor, you're gone. I don't want you at all, go away. And you, as the contractor, say, you've wrongfully terminated me. I didn't do anything wrong. So the ultimate issue in here is whether somebody did wrong. But we got all this steel that the contractor is expected to purchase from the subcontractor. Let's say it's $1 million worth of steel. And it turns out, as we proceed along in the lawsuit, it turns out that yes, as the owner, I shouldn't have terminated. The contractor did nothing wrong. The contractor is going to come back and say, I'm entitled, if there's the consequential damages, I'm entitled to my lost profits, I'm entitled to all the work I've done thus far. and I need $1 million for that steel that I purchased, even though there's not 1 ounce of it in your project and you haven't received any of the value of it, I had to pay for it, and I'm out $1 million because I got a pile of steel that's for your building, but you terminated me, I'm not putting it in, and I had to pay the subcontractor, and the only reason why I have that steel is because I bought it for your project. I did nothing wrong, the court said I did nothing wrong. Not only do you owe me for the money for the work I did do, but you owe me the money for buying the steel. Pretty good theory, right? He expended a cost because you asked him to. It was his expectation that that steel was going to be assumed by me and that he was going to get paid for it. That's a good expectation damage argument. Pretty solid. I'm the owner of that. I'm going to say, did you try to sell any of that steel back to the steel supplier? No. Did you try to sell any of it on the open market? No. If I can show that pile of steel, that $1 million of steel, at minimum on a salvage value to sell to a smelting yard to be manufactured into new steel, has a value of $200,000, they have failed to mitigate their damages. And I would not owe $1 million, I would owe the difference between their damage claim and their amount of the value of their failure to mitigate. So I would owe in that instance $800,000. Because while they have an expectation for me to pay for their work, their product that they purchased on my behalf, well, it's not in the contract, but it's implied in every contract, I have an expectation that they will mitigate their damages. Does that make sense? One other type, this is where that can't take advantage of it. This would be a concept called betterment that comes in construction, but it's still a failure to mitigate damages. So we go to this wastewater project that I was talking to you about. The owner was a city in a small little town in the western side of the state of Illinois. They hired an engineer, a contractor to design and build their wastewater treatment facility. And the contractor retained my client to provide the pumps. All in the construction, the design and the construction of this wastewater treatment facility was about $600,000. And the owner paid for it. And it didn't work. And they tried to fix it. It didn't work. They tried to fix it. It didn't work. And then the owner of the city just terminated everybody and brought in a brand new designer and builder. And they built a brand new wastewater treatment facility, completely shucked everything that we used. Brand new, and they spent almost $2 million on it. $600,000 facility, almost $2 million. The pumps that we supplied were like a Chevy pump. Solid, dependable, always working, no fancy bells and whistles. They're used in lots and lots of these facilities. The pumps that they installed were like Ferraris. Upgraded, souped up, everything you ever wanted in a pump. So when they brought the lawsuit for the almost $2 million to recover all of the money that they spent on the new facility, one of our arguments is you took advantage potentially of our breach. You failed to mitigate your damages. Not only did you fail to mitigate, but you actually got a better product. You originally bought and paid for a Chevy. Now you're driving a Ferrari. We are not required, even though it's not in the contract, it is an implied term of contract that you mitigate your damages and you don't take advantage of us. So in the first instance, the mitigation of damages in the steel was they failed to sell off and try to recover or recoup some of their losses. And the second advantage, this one with the wastewater treatment facility, is they actually, what we believe, and this never got all the way for a judgment in front of the judge, what we believe is that they actually took advantage of the situation. Not only did they not try to recoup their losses, they took advantage. In both of those instances, those are the other side, the defendant's arguments against how much they have to pay. Make sense? All right. That's it. Yeah? Pardon me?
I think we meant to really sell out those materials. And we use the water for, put them guess, creating fluctuations. I did not want to sell it off.
To sell the materials, you said what I mean by that?
Right?
You're asking what I meant by to sell off the materials?
No, I mean, those materials, the one you talked about.
The steel?
The pump.
The pumps, yes.
Yeah. So, the one that was the operating one.
Yes.
That's a different material.
It was a different pump, a different manufacturer. It was like literally, I mean, if you look in the industry, our pumps are considered the Chevys of the industry. They're solid, they're standard, but they don't have anything special about them. They just work. There's nothing fancy about them. When the city came in and hired the new engineer and the new contractor, they said, "We recommend you buying this pump. It's the top of the line model." The reason why they recommended that, in our opinion, was because they were both the designer and the builder. They would make more profit off of it. Because the markup that the contractor could charge on a more fancier top-of-the-line model, they'll make more profit on that than they will on the regular pump, because their profits are based off percentage. So think about it this way. In construction, contractors make their money by what's called a markup. So traditionally, a contractor's markup is going to be somewhere, depending on how big the project is, somewhere between 5 and 15%. Let's just take 10 as an example. If I sold you a $200,000 pump on a 10% markup, that's $2,000 I'm going to make. If I make it on a $400,000 pump, that same market is going to be double that. So it's to their benefit, we would argue, that the following contractor, to have a larger markup on a more expensive pump. And the owner went ahead and went with the more expensive top of the line, and we say, but you originally only bought and paid for your bargain. What you expected for was the Chevy. You are not allowed to get more than what you originally bargained for. That's a betterment. So,
who purchased the normal pump, like the ordinary pump? Who purchased the real client?
well, my client was the manufacturer, so it was bought by the contractor, and then the contractor sold it to the owner. So the owner ultimately purchased our pump. And then that pump didn't work for a whole host of reasons I don't want to bore you with all the reasons and the flows and dynamics and everything else of why the thing didn't work and whose fault it was. But when the new system was redesigned, they didn't come back to my manufacturer, they didn't come back to my client. They got a new contractor, and that contractor, working with their architect, because it was one firm, said, let's get a totally different manufacturer, a totally different pump, and then the city bought that. Does that make sense? So, okay. All right. We'll see you guys next week.